The content of this video, as well as the thoughts, views, and opinions expressed herein, belong to the presenter and do not necessarily reflect the views of Brigham Young University or the Church of Jesus Christ of Latter-day Saints.
Hi, I'm Rob Bolick. I'm an attorney practicing my career mostly in Nevada and Utah. I've been doing this for 43 years now. So I graduated from BYU Law School back a long time ago, and this is what I've been doing. So today we're going to talk about asset protection, the things that work and the things that don't work. So let's go ahead and jump in. So some of the basic asset protection principles are, number one, which of your assets are already protected? So some of the things you have, don't even have to worry, you're already covered. We're going to talk about LLCs. We're going to talk about the new kid on the block, which is Series LLCs. We're going to compare and contrast LLCs with corporations. And then the next lecture in the series is asset protection trusts. These are the most effective, the strongest thing available for us today. We're going to talk about how those three jurisdictions, Nevada, Utah, Wyoming, provide excellent protection. You don't have to be a resident of those states to be able to use their laws. We're also going to discuss how to supersize your homestead exemption. Just using Utah as an example, Utah's the worst of most of the states that I know of. There are a few worse, but not many. The Utah homestead protects only $42,000 of equity in your home, or if you're a married couple, $84,000. But still, you may have more equity in the home, and bad guys can get it. And so, how can you protect it? We're going to talk about that. Okay. So, first of all, what asset protection is not? It's not avoiding taxes. A lot of people think that somehow this has to do with taxes. Absolutely not. It's completely tax neutral, doesn't help, doesn't hurt, zero as far as taxes. So it's not about avoiding taxes. It's about protecting your assets, and hiding them doesn't work in our day and age. You've got to assume anybody can know anything you have within a matter of minutes. And even if they can't find it on their own, if something happened to you, you had a lawsuit, have a judgment against you, you'd be required to go into court and disclose everything that you have and where it's located. And so unless you're into perjury, that's not going to help. Another thing are what we call fraudulent transfers. Typically, these are things that happen either after the fact or in anticipation of a lawsuit, squirreling away assets, creating bogus liens, things like that don't work. So what is asset protection? Basically, it's taking simple steps now to arrange your affairs in such a way that you're protected as opposed to not protected. So we'll start with some basic definitions. Good guys are you. Bad guys are anybody who's trying to separate your assets from you. So world is very binary as far as this is concerned. Question, do truth and justice always prevail? We happen to know the answer of that, not in this life. As my dad used to tell me, the only time you'll ever be offered justice in this life, you will absolutely decline it. You will not want justice. You want mercy, forgiveness, and that. Okay. So in this life is not always fair. Not everyone plays by the same set of rules or has the same moral compass as you do. So also, as we know, truth is stranger than fiction. Again, as I mentioned in the last lecture, my dad used to tell me, well, you know why? It's like, I have no idea. And he says, well, fiction has to make sense. Real life does not. That's not one of the ground rules. So let me go through an example. I have a wealthy client. He had a 22-year-old stepson living at home. Okay, so good facts, namely not his son, so no legal responsibility. 22 is more than 18, so no legal responsibility there, but that never prevents somebody from suing if you happen to have a lot of assets. So the key here is he was driving his stepfather's car, so that's where the liability came in. So driving Dad's car, stepfather's car, stops at the stop sign, turns right at the intersection, look left, turn right, hit a lady in the crosswalk. She claims severe back injury. We happen to know that wasn't really the case because she ran a marathon 2 weeks before trial, but for whatever reason, the evidence was inadmissible. So as far as the jury knows, no, she was, irreparably damaged. Got the verdict for $4.5 million. That's a biggie. And unfortunately, his insurance limits were only $300,000. That was the minimum required under statute. And so if your math is good, you can see that comes up with $4.2 million deficit. Now, this could be tragic, but fortunately there was a good result here, namely my client, he'd come in 4 or 5 years earlier, had set up all of his asset protection things, and everything that he owned was safe. And so the plaintiff only got the $300,000 of insurance, probably more than what she deserved, but that's what she got. And good news for him is he didn't have to come out of pocket, although probably would not let his stepson borrow the car, which obviously is good advice for all of you. Once your kids turn 18, it's cheaper to keep them on the insurance, but there is that downside of potential liability. So, word to the wise, be careful. So, moral of this story is justice is imperfect, and the bad guys get away with bad things, and bad guys could be out to get you. You never know. So, some of the unfortunate facts of life are, whether you're right or wrong, the facts of the case can only marginally be relevant. A lot of times it depends on what you have, not what you did. Are you an attractive defendant? Do you have, substantial assets? Well, you could be a potential target. So, and it's not just the proliferation of personal injury attorneys and others. You drive down the freeway, I-15, you look and there's billboards everywhere. Have you been injured? Come see me. I'll take your case. I don't charge you anything. We do it on a contingency. We'll get a bunch of money, and I'll get some and you get some. But in the meantime, costs you exactly zero. So, what do you have to lose? People do that all the time. How you can tell it happens all the time is you see more and more billboards. Those things are not cheap, and they do pay for themselves. So, essentially, this is a shift in our society's morals and values. A lot of people think, oh, well, I want a free ride. Everybody's looking for a handout. I want free stuff without having to work for it. This fits within the mindset. Sad, but that's kind of the direction that we tend to be shifting. So, another case of truth is stranger than fiction. Man came to see me. He was in his early 80s. Bad news. His wife was in a car wreck. Well, whose fault was it? Well, she hit a lady on a bike. Okay, well, that would be your wife. Okay. Gotta look out for these things. Older you get, the less capable you can become. So the good news is she wasn't going fast. More good news, the lady skinned her knee. Well, this sounds great. Get up, ride your bike off, no harm, no foul. Except, bad news is she went to see an attorney that doesn't have the same moral compass that we do, and he decided to sue for $4 million. So this is how, I can't say the game is played, this is how the system works, is you go for some obscene amount and know that you're not going to ever get it, but you start out high, and that's just what you do. And so for him, once he's been sued, now he has to hire an attorney to defend himself. So number one, it's going to cost him some money. He's not going to get as much sleep as he used to, anxiety, stress, depression, or whatever. Just lose part of your stomach lining and some sleep and definitely money. So marginally good news is another thing is, in this particular situation, say in a car wreck, what will happen is he has insurance. So one of the things, first thing he'll do is he'll notify the insurance company that there's going to be a claim against the policy. And so the insurance company will take one of their attorneys in staff or one they contract with, to defend him the client, the defendant. Basically, though, what the insurance companies are looking for is what happens within their policy limits, what happens above their policy limits. They don't have nearly as much interest in the matter as the client does. So it does have the insurance company's attorney to help him as the defendant, but he has to hire another attorney to protect him on whatever it is, above the policy limits. And so still going to cost him some money. Bad news is he couldn't get him to go any lower, so they're still involved in this lawsuit, and not good for him. All right, more facts in our day and age. You will never be invisible or invincible. That only happens in Marvel Comics, maybe DC Comics, but not in real life. And basically, you don't want to be an easy target. So, question, can you prevent yourself from being sued? Most people say no, but there actually is perhaps a way. So the general concept is no, you cannot prevent anybody from suing you. What you can do is you can arrange your affairs in such a manner that it's not worth their while to sue you, so hence the answer possibly. What you can do is prevent them from getting any benefit from doing it, and that can put a big damper on the whole party. So what you can do is you can protect your assets in such a way so that they can't get whatever's there. All right, so the analogy here would be the bear. You know the story, you're probably familiar with this. Two guys are out camping, they're in the woods. They hear the rustling in the bushes. This big bear is kind of coming their way, and it's like, oh, we're in trouble. The one guy sits down, starts lacing up his shoes, and his buddy says, oh my gosh, what are you doing? Don't you know you can never outrun a bear? He said, I don't need to outrun the bear. I just need to outrun you. So concept here is you don't want to be the low-hanging fruit. You don't want to be the easy targets. You don't want to be the one that doesn't take a lot of effort for somebody to go after. So you can take steps now to protect yourself from the unknown, unforeseen, whatever may happen. So the goal is to protect yourself from the bad guys, especially the ones that are dishonest. Okay, question, are all laws, rules of equal value or importance? Everybody realizes, no, that's not the case. Do all of the laws and rules make sense? And if you've been around for a while, you know that doesn't make sense either. So we have you living here, day and age, you have stuff. You have all these potential people out there that may come after you for whatever reason. You don't even know what it would be. And there's a whole set of laws. And so what you want to do is be able to know the laws, take advantage of what's out there to protect yourself against the unknown, unforeseen. So here's one, please keep off the landscaping. Well, that does make sense. I mean, you don't want to trample plants and whatever. Makes sense in isolation. If you look in context, it really doesn't. So what there's a city ordinance. You have to have this every 60 feet or something, and so they have to do it because that's what the law says, but it really is kind of silly. Okay, you've all heard of the saying, ignorance of the law is no excuse. True or false? You all know it's true. Not going to help you. So similarly, ignorance of asset protection laws is not going to protect you from those that are out there. So this also has historical precedent. You know this guy here from Old Testament. If you ever get frustrated with certain laws, there is some history behind you. So, and we're also no longer living under the higher law. We're going to trash those and be living this lower law, which happens to be like the 10 Commandments. And wouldn't it be nice if people actually did that today? We are much lower than that law. So here we are, day and age, what are we going to do? So what will protect you, your family, your assets from a disastrous situation is, again, you just arrange your affairs in such a way that no matter what happens, nobody can get them. Okay. General asset protection principles. It's not, I see this as a justice system, not a legal system. Or it's not a justice, it's a legal system, rather. Again, justice, you can get that next life, not always going to get it here. So it's a legal system. We're dealing with all of these laws. Okay. Question, is asset protection legal? Well, yes, we wouldn't be talking about it if it weren't. So there are very easy things you can do, well-established legal principles that you can take advantage of these if you know them. Is it ethical? Well, I'm going to say yes. No need to expose yourself to people that may want to come after you for whatever reason. They claim $4.5 million damages and for $4 million for a skin knee or whatever it happens to be. So the objective is to know their rules and take advantage of them. Okay. Justice hand. There are two systems of taxation in our country, one for the informed, one for the uninformed. Most people will say yes. Question, who's going to pay lower taxes? Well, it's going to be those that know the rules. In my opinion, it's the same thing applies to asset protection. Know the rules, take advantage of them, you're going to be better off. So what is the objective? If we're going to go back to Nature Channel, is to look like a porcupine. So you're there, you got the big bad wolf, a predator. We want to avoid that. So what are the attributes of a porcupine? Slow moving. So you're never going to outrun them. You can't jump over tall buildings in a single bound. You're not faster than a speeding bullet. You're just there in plain sight, plodding along. You're not invisible. There's no force field. You happen to be a tasty meal, but in this case, it's really not worth the effort. So again, you're not hiding, you're not running, you're not doing anything. What you have done is you've arranged your affairs, so you put a bunch of quills on, figuratively speaking. And even though it's potentially they could come after you, they're not going to do it. Okay. Next point is timing is important. The general rule is the longer you have these things in place, the better it is. Okay. Particularly, like, you can be 100% safe if you have it done before the liability arises. So, you know the common saying, the time to repair the roof is when the sun is shining, not when it's raining. You got to think in advance and take the steps when you have the ability to do so. When it's a bright sunny day, sun shining, birds singing, clouds, very pleasant. All right. So one of the things people say is, well, I know what I can do is I'll just get lots of insurance. Insurance is good. I kind of go with the Goldilocks principle of you just want whatever is just right. You don't want too much. You don't want too little. You want whatever is just right. So insurance is good. Don't get too much. That makes yourself a bigger target. Don't get too little. Then you can be underinsured. So, however, there are some potential disadvantages to this, which most people don't think about. Number one is the claim may not be covered by insurance, and the other is it could exceed policy limits. We're going to talk about that more in a minute. The paradox is insurance attracts litigation rather than deflects it. Okay, it's not a magic force field that'll prevent somebody from suing you. What happens is the bigger the pot of gold at the end of the rainbow, the more attractive you become as a defendant. So again, too much is not good, and frankly, insurance, again, is a lightning rod. It attracts litigation. It doesn't prevent it. So here's an example that an insurance person told me. Insurance covers you from falling off the roof. Okay, I've got that kind of insurance. That's excellent. Unfortunately, one of the exclusions is hitting the ground. So whatever you have, you want to make sure it is good for the purpose. All right. Again, truth is more scary than fiction. So this was a client of mine in Nevada. He was a plastic surgeon. He was working from his office, namely surgery center, meaning he wasn't in a hospital. If he were in a hospital, he would have to maintain insurance, but he had a cash business. So if you're going to be a doctor, this is a good way to go, if you can do that. Anyway, he told me that he actually did commit malpractice, not once, but several times, but he was never sued. Okay, you got me. What's the catch here? And you might be able to see it coming is why he wasn't sued is because he didn't have any malpractice insurance and he didn't have a lot of other assets. And so even though he had legitimately injured these people and they had a legitimate cause of action, a claim against him, he was never sued because there was nothing to get at the end of the day. And so this is kind of the Martin Van Buren principle of your cause is just, but I'm not going to do anything. So first thing that happens if you plaintiff has a claim, I've been injured over whatever it is, go see an attorney. The attorney says, wow, this is good. You have good facts. The law's on our side. Everything looks good. Before we file this complaint, let's take a look at the defendant. Let's see what the defendant has. And if it comes up as nothing, the attorney is going to say, you know what, I'd love to take your case, pay me $50,000 and I'll go to work, and they're going to say, rather not. Contingency, nobody's ever going to do that unless they're assured of some big payday at the end. So again, you can take these same principles and apply them in your life. So what is the moral to the story is if you can work for the bad guys, you can also work for the good guys, namely you. Okay. Further good news, there are laws out there that can enable you to protect yourself against anything that can happen. So why not use them? They're there. If you know about them, use them. Okay. What I like to think of is doing asset protection is like asset insurance, or as one client told me, is sleep insurance. With the stuff in place, it really doesn't matter what happens. I'm okay. Okay. So what is your goal with insurance is to never use it. Okay. You have high-end medical insurance. You don't want to go in the hospital for a year and have, $1 zillion of bills and have the insurance pay for it. You never want to go in the hospital in the first place. Again, as we talked about earlier, life insurance. Life insurance is a bet you want to lose. You are betting the insurance company that you're going to die. They're betting you that you're not. You pay them money. Not that I hope I die, but in case I do, I'll get paid back. And so anyway, that is one example of a bet that you want to lose. And so in the asset protection arena, generally whatever you pay for to get your entities, your things in place, you're happiest if you never have to use it. You want it to be wasted money because you never got sued. Okay, so let's just go to some of the basics. Do you have a home? Yes. Do you have fire insurance? The answer is yes. Clearly, if you have a mortgage, would you have insurance even if your lender didn't require it? Most likely, yes. Why is that? Because you just never know. So in the asset protection arena, question is, what is winning? How do you win? Okay. In my opinion, winning is not going to court, going to trial, prevailing on the merits. Truth and justice do prevail in this case. You win, they lose. Okay. That is not really winning because you've already lost your time, money, sleep, etc., stress, anxiety, etc. So winning is not going to court and winning. Winning is never getting sued in the first place. So how do you avoid being sued? Well, obviously, you just look like a porcupine. Okay, so that's the concept. Let's move on. So question is, as I alluded to earlier, are any of my assets already protected without me having to do anything? And the good news is yes. So any of your qualified plans, IRAs, 401ks, the old ERISA plans, whatever you have, anything in the nature of retirement, including government pensions, all of that are protected. So that's the good news. Also, another thing you can do is state homestead laws can protect your primary residence. Now, it has to be your primary residence, like you have to live there. It doesn't cover rental properties, second homes, other things there. Okay, so here's some examples as of now of various different states, mostly here in the West, of different homestead protections. Now, essentially what the homestead protection does is it protects that much equity in the home. So if you have a $500,000 home and a $400,000 mortgage, you've got $100,000 of equity, you're pretty much protected under most states. If you have a $500,000 home and a $100,000 mortgage, you've got $400,000 of equity and you can be exposed. So the good news is there are some things you can do to protect your house, which is or quite frequently your most valuable asset. Okay. So let's go to, so those are the things, IRA, 401k already protected. Homestead laws can do some protection. You do have other assets, savings in the bank, investments, other things, second home, rental property, blah, 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 whatever you have. So let's talk about those for a little bit. Let's talk about also what does not work, okay? One of the things that I can't believe people still think that this would work is, oh no, I think I'm going to get sued. I'm just going to transfer all of the assets out of my name into somebody else. Good idea, not even close. Number one, there's tax consequences in transferring them. You never know whoever you pass it to is going to be okay, and what happens if they get sued? And I gave my house to my brother, and now he got sued or he got divorced, and my home is gone. Never works. Even if it possibly could, the main reason is what we call the F word, and this is fraud. Okay. Making a fraudulent conveyance, if you make yourself insolvent by giving away assets, that's the easiest thing in the world for a plaintiff's attorney to set aside. Okay, a slam dunk. Here's another thing. People say, well, here's really easy. I have $400,000 equity in my home. I'm just going to file a lien in favor of myself as a second mortgage on the property. Good idea? Not really. Okay. Again, a bogus lien can be set aside. Again, that's a slam dunk. That's really easy if it's not bona fide. I borrowed $300,000 and I gave the lender a $300,000 note and secured by a second deed of trust on the home. That will work. Just recording the lien on the property without underlying substance, not going to work. Okay. Again, that's the F word. All right, so here's another thing. Cleaning out your financial and hold it in a safe deposit box or under your mattress. Or used to say a coffee can in the backyard, but we're going to say postum can for LDS. All right. Why is that? Again, this is the P word, perjury. Okay, so what happens here is if you are sued, if you have a claim against you, the judgment creditor can haul your little tush into court, and you have to swear under oath, under penalty of perjury, everything you have, everything that's located, what you did with it. So unless you're into committing perjury, this is not a good thing. All right. So what are some of the tools that we have? So we talked about what doesn't work. Well, what will work? Let's talk about LLCs. Most of you are already familiar with the concept. You know that these such things exist. You just maybe know more about it or maybe not. So limited liability companies can provide excellent asset protection. Okay, that's the good news. Further good news, they're easy to create, set up, easy to operate. Tax compliance is easy. They're basically just really easy, and they're also really cool. So what are the kind of things that you might want to create an LLC for? Basically, it's anything that could generate liability, such as a business or let's just say rental property. So the concept is you create the LLC, you put the asset inside of the LLC, something bad happens in the business, slip and fall on the property, whatever it is, because it's in the LLC, the creditor or the claimant cannot pierce through the veil and come after you personally. So LLCs, very basic, simple thing that you can do to protect yourself from any potential liability asset that you hold. Another thing you can do is you can even create an LLC as your ironclad piggy bank. You can set up the LLC, hold investments in there, and you set it up properly using the right states, the right statutes. That'll work too. So it's a very inexpensive and fast, easy, user-friendly way to protect assets. Okay. Furthermore, on the issue here of, well, if that's so good, how about my primary residence, my home? I have a lot of equity in there. Can you use an LLC to protect your primary residence? And the answer is no, you can't. And people get surprised, like, well, I can protect a rental, yes. I can protect my business, yes. I can have my $100,000, CD in there, yes, yes, yes. Why not my home? You're going to have to hold that thought. We're going to discuss that a little bit later, but just to check that one off the box, no, it doesn't work for your home. Okay. So again, can I use it for investments, savings? The answer is yes. The same principles apply for liquid assets. Now, in this case, you don't set it up to protect yourself from your liquid assets. Your bank account is never going to sue you. That's not why you set it up. The nice thing about LLCs is they work both ways. Not only does it protect you as the owner from any liability that happens within the entity, but somebody who's coming after you personally cannot pierce through the veil and attach the assets in the LLC. We're going to dig a little deeper on this. So, does an LLC really work for asset protection? Oh, yes, it does. How does it work? Well, this is all statutory. Again, comparing and contrasting what we've talked about before. Trusts are a private instrument. A trust is not filed, it's not recorded, it's between just you as the creator, the grantor, you as the trustee, you as the beneficiary. So not filed anywhere, nobody ever knows that the trust even exists. The only exception to that would be if they know you live at 123 Elm Street and they go to the county recorder and see that your home on 123 Elm Street is owned in XYZ Trust. They will know that XYZ Trust exists. They don't know anything about it. They'll assume that it's you, but again, it's an assumption. So trust, strictly private, LLC, very public. So that is filed with the state. So what is of record would be in an LLC, two things are of record. So you have what are called the managers, which is you set it up for yourself, John and Mary. It'll have your address, it'll have information about you, and also number two, the registered agent. So there needs to be a legal representative for the entity, which can also be you or whoever assists you in helping you in setting it up. So the registered agent, the purpose for that is if the entity ever gets sued, how the plaintiff will perfect service of process is to hand it to the registered agent. That perfects the service against the entity, not against you as the managers. What is private in an LLC are the owners, so nobody knows that it's you. But you have the managers, you, and registered agent, could be you or somebody else. Okay, so that's what's out there in the public domain. So let's just do an example here. We have John and Mary, and they have a rental property. So great, let's set up an LLC. Perfect. Create the LLC with the state. Then you deed the property in there for rental property. For real estate, that's how it's done, is with a deed. So I set up the LLC, deed the property in. Okay. We all know Mary would never do anything wrong, of course. John gets sued. Bad guys win. So what happens? What can the creditor do? In this case, judgment creditor. He's won at court. I've just used this as Nevada statute, similar thing in Utah, the other states all around here, is what the creditor gets is what's called a charging order. So again, John got sued personally as an individual. The creditor cannot attach the property because John doesn't own the property. The LLC owns the property. John owns the LLC. So what the creditor can do is attach what John owns, namely the membership interest in the LLC. So he has the judgment, and they got a charging order, which essentially you got to think of it as, say, a lien on the membership interest, on the ownership interest. And so under the state laws, it's really good. What rights can the creditor do? And the answer is not a whole lot. That's the good news. Okay. Essentially, the bottom line is sit on his hands and wait for a distribution. So how this works is, say you have net income within the entity. Okay. Under the tax laws, you're taxed on all income. John is taxed on all income that is generated in the property, whether or not it comes out. We're going to touch on this more later. But he has net income in there. He has a bank account in the LLC. He's going to keep the money there. He's not going to take it out because the creditor has liened his interest. If he took the money out, the creditor would get it, and so he decides to leave it in. Okay, so the key here is the creditor has an economic interest only, not a voting interest. So yes, I have attached it for financial purposes, but the nice thing about the state laws, generally how corporations are not as good as LLCs, is that the statute says that just has the economic interest, not the voting interest. So what does this mean is they don't have any control. So what can the creditor do? And that's not much. Cannot, number one, attach the assets. Without the voting control, he can't force a distribution. He can't force John to take the money out, nor can he force a dissolution. He can't force him to pull down the barrier and allow him to get in. So we're kind of at a stalemate at this point. So you have net income in the LLC. He's not going to take it out because the creditor could get it. He's going to leave it in there. And so the creditor can't get in. He can't take it out. Again, we're at a bit of a stalemate. But wait, there's more. Let's say Stephen King couldn't create a more frightening story, and that is drumbeat, IRS is my friend. Ooh, scary. So how does this work? And the concept here is the more taxable income, the better. So tax consequences, again, John and Mary are taxed on the income of the LLC, whether or not any is distributed. Okay. So, example, the LLC earns $100. John reports it, John and Mary on their 1040, regardless of whether any money comes out. So here's what we have. We have a revenue ruling, IRS, which is the key to having this thing work very well. And basically what it says is, if a creditor has attached your interest, your ownership interest, they, again, have the economic interest, not the control, and so they step into this debtor's shoes for tax purposes. So what does that look like? So here's the creditor. I didn't put horns and pitchfork and pointed tail on here, but that's what John thinks of him. So creditor wins, John loses. He has asserted the charging order lien on his property. And so what does this look like is, again, he steps into his shoes for tax purposes. And so John can choose not to make a distribution. Somebody's going to pay the tax on this. It's not him because the creditor has liened his interest, has stepped into his shoes for tax purposes, and John issues him a K-1. And so this is commonly known as KO by K-1. So what if John is fortunate enough to have the creditor be foolish enough to assert a charging order lien on it, then the creditor has to report all the income. So if the creditor has a knowledgeable attorney representing him, they may not even seek to assert the charging order lien in the first place. And or if they do, it's not going to last more than 1 year if they have a taxable event because of it. So it's phantom income. I got to pay the tax and I didn't get any money. That's not an attractive thing for a creditor. And so generally going to at least take the lien off the next year. So that's how that, again, what you want to do is know the rules, use them to your advantage. This is a nice thing that you have as an LLC. Okay. Question, when does asset protection become effective? And the good news is it's immediately. So I could set up an LLC on Monday, transfer my assets in on Tuesday. Wednesday, I'm in a car wreck. Thursday, I get sued. Are my assets protected? The answer, of course, is yes. The asset protection is immediate. He created it. He put it in before the liability arose, and it works. If it were the opposite, he got in a car wreck on Monday, set it up on Tuesday, put the assets in, get sued, not going to work. That's, again, the fraudulent conveyance. Okay. Now, here's a little twist caveat. There's only 5 states that provide charging order protection for single-member LLCs. They happen to be Nevada, Wyoming, Alaska, Delaware, and South Dakota. These are also probably the top 5 states for asset protection. in asset protection trusts, which is the next lecture in the series. So what you have to do is, let me back up. So the single member LLC means that I have a trust set up. I can have my LLC owned inside of my trust 100%. Okay, single member LLC. If you're in one of the other states, it's an easy thing to do. You just change the ownership a little bit. You can have John own 1%, Mary own 1%, the trust own 99%. There's ways around it, but for a single member LLC, for a little simpler, easier, slicker, use one of those jurisdictions for setting up the LLC. A lot of people ask, well, what if I don't live in Alaska, Delaware, Wyoming, South Dakota, Nevada? Yeah, you can certainly set up an LLC. No problem there. And little historical note, LLCs were invented in Wyoming, as well as my mom and grandma were born there. Brigham Young, actually, pioneers went there way back in the 1800s. Hard scrabble life, but anyway, the Wyoming legislature is progressive as far as trying to protect people. LLCs invented there. All right. Also, Wyoming, historical fact, the first jurisdiction, the first state to allow women to vote. So, yay, Wyoming. All right. Okay, contrasting, are there any differences between corporations and LLCs? And the answer is yes. So, which are better? Well, actually, it's LLC. So corporations go back quite a few years. That was the cool thing for asset protection. So I'm running a business. I'll open up a corporation. I'll do it through the corporation. Something bad happens in the business. They can't come after me. All of that is true. There is some of the differences. Let's go over that. Why are LLCs better? How does it work? Okay. So let's just take corporation. Facts are John and Mary have a corporation. They got stuff in their corporation. John gets sued. Question, can a judgment creditor attach the assets of the corporation? And the answer is, yeah, they can. So how does this work? Is John and Mary, they own the stock or a controlling interest. So again, John gets sued. The judgment is against him. Creditor can attach anything that John owns. John doesn't own the business, the assets, the rental, the whatever it is in the corporation. He just owns the stock. So judgment creditor attaches what John owns, which happens to be his stock. The issue here with a corporation, you do have the voting control, and you can pull down the barrier, you can make a distribution, you can do whatever, and be able to access the assets. Fortunately, the opposite result happens for an LLC. So the terminology in an LLC, you have what's called membership interest. That's the ownership interest. So stock of a corporation, membership interest of an LLC. So John and Mary own 100% of the membership, the ownership of the corporation. Creditor can attach that. That's what John owns. But the LLC laws say under the charging order statute, you can't get in. Okay, so what used to be really nice in a corporation now is even better in an LLC. Now, in response to this little defect in the corporation, a lot of states have adopted statutes that give corporations the same asset protection features of a charging order, the same as an LLC, to try to balance the playing field, which is certainly a step in the right direction. Depends on what state you live in and where your corporation or LLC is set up. The one thing that I still like about LLCs over corporations is whenever you have a corporation, it requires a tax return. So either an 1120, IRS Form 1120 for a corporation, or IRS Form 1120-S for an S corporation. So even if you have an S corporation, which is a pass-through, C corporation, double taxation, S corporation, pass-through, S is generally better. One tax is more than enough. You don't need to do two. So C corporation has its place, but beyond the scope of what we're going to talk about here. S corporation better for most things, but LLC is even better if you have the LLC taxed as a disregarded entity, which is what I recommend, how we always set ours up. You don't even have to file a tax return. You just report all of the income directly on the client's 1040 rather than having an 1120 or 1120-S and a 1040. So you can save yourself some expense and whatever by having it as a disregarded entity. So again, Tax consequences, are there any tax consequences in contributing an asset to an LLC? Good news, no. How about taking assets out? Well, also no, but again, this depends. So no if it's taxed as a disregarded entity, a partnership, or an S Corp. Okay, no extra tax. Yes, if it's a C Corp. Again, beyond the scope here, but C Corp generally not good for your own personal, holding company to protect your assets. So I like to think of an LLC as the ultimate chameleon. Namely, you can have the tax consequences be whatever you want. So again, my favorite is a disregarded entity. IRS disregards it as an entity. Namely, we're going to pretend like it's invisible, and you earn $100 here, you report it on your 1040 as $100, the same as if the entity didn't exist. Okay. The nice thing, again, is no return is required, and this is allowed in an LLC if it's just one tax return. So a single person or married filing jointly can have it be a disregarded entity, not if you have independent parties with different tax returns on there. Then you'd have to file either partnership, IRS Form 1065, or again, 1120S or whatever you're going to do. So how do you blow it? How can you pull down the protective barrier? So what you do is you don't respect it as an independent entity, okay? So it's important if you're going to set this up to have all of the documents in place. Now anybody can set up an LLC, go online, Secretary of State, fill out the form, click the button, pay the money, and presto, you have an LLC. That would be just the first step. I certainly don't advise people to go that far. It's better than doing nothing, but if you want this to work for asset protection, it truly has to be an independent entity. And so if this is different than you, what you're going to do is, again, number one, file the articles with the state, but then you're going to have what's called an operating agreement, similar to bylaws of a corporation. Here's what we can do, here's what we can't do of the members of the entity. You would create the organizational meeting minutes I'm going to elect the managers, we're going to make whatever tax elections on the entity, we're going to issue the ownership, we're going to then get a separate tax ID number with the IRS, and filing whatever compliance is with the Secretary of State to make sure that it's all good. So if you set it up properly with all of the trappings, bells and whistles there, it looks, it acts, it smells, it quacks like a duck, you just want it to be the entity that independent of you. So what you'll want to do is you'll want to open up a bank account within the LLC, and you want to do all business through that. You do it personally, you're exposing yourself to a claim under an alter ego theory. If I treat it as the alter ego of myself, then the creditor can too, so you got to be careful. So one of the big no-nos is never pay any personal expenses from your LLC. If you're going to do that, you distribute assets from the LLC to your personal bank account if you happen to be the owner, or to your trust if the trust is the owner, and then from the trust account to you personally, whether it's a one-step or two-step process. Then you make your personal expenditures from your personal account. You're not dipping into the LLC. You're not pretending like it's your personal piggy bank of making direct expenses, but you can make distributions and spend from there. So again, you don't want to open the door under an alter ego theory of I'm treating it like it's my own personal private entity, even though it is. You have to treat it as an independent one. Okay. One of the questions, can an LLC own property in other states? Well, yes. Do you need to register it? The question is, do I have to register that to do business in the other state? And the answer is no, with the exception being California, which they like to tax no matter what. And California is $800 to set up an LLC and $800 a year franchise tax board to maintain it. So common thing for an LLC is rental properties. If you ever have any rental properties, Law 101 says set up an LLC. So moving on. New kid on the block is Series LLCs. These are kind of custom made for multiple rentals or multiple business activities. So what this says is that you can set up one LLC, and again, Utah, Nevada, Wyoming all permit these. California, larger states, no, never happen. Okay. So you set up one LLC with the state, and then you can create as many different series or compartments within the LLC as you care to. Each one of the series, each one of the sections within there acts for legal purposes as if it were a separate LLC. So, for example, I have 3 rental properties in 3 different states, whatever. I can set up one LLC. I can set up 3 series and 1 property in each one. Something happens on one, it's not going to affect whatever is in the other series. What are the advantages of that? Well, you just set up one LLC instead of 3. Okay. You just have one initial fee, one annual fee. It's really good. Is there any limit on any number of series you can set up? And one guy at a seminar said, I just said 1 million. And then he came up to me afterwards and said, now what's this 1 million limitation? I go, no, I was being facetious. There's no limitation on the number of series you can set up. So whatever you have, you can do it. Okay. All right, here's just an example of what this may look like. So let's say you had, within the Series LLC, you have Series A, Series B, you got a rental property, you got a second home. You can put those within the Series LLC. I wrapped an FLP, Family Limited Partnership, just for fun. We didn't have time to talk about that, but what can happen here is you can prevent, as you see, the creditor from attaching any distributions that you make from your LLC if the money was held there. Also, if you have rental property, you don't want to keep the money in the same account that you have your account for the LLC, because you don't want to store excess money in case something happens there. You want to take all the money out. So you can wrap that one entity inside of another entity, and the money is then distributed from the LLC into the holding entity, either another LLC or a limited partnership or something. And then something happens to you, again, just in the LLC, in the limited partnership, how you set that up. Limited partnership requires 2 partners, similar to most LLCs. So you have John individually as the general partner owning 1%, and then you have the trust as the limited partner owning 99%. And so John gets sued, and the creditor can go straight through the living trust. Again, living trust, 0 asset protection. What we're talking about in the next seminar section is asset protection trusts, which will give you asset protection after the assets have been held for 2 years. So it does take a little time for it to season, but just taking this as an example of living trust, they can't get through. Okay, so here's the nice thing about having things within your trust is, can you distribute profits from the limited partnership free from a charging order? And actually in the trust you can. So yes in a trust, no in an entity. All right, so that's just kind of a little picture there. Getting back to the point of how do we protect our home. As I indicated, you can't protect your home in an LLC. How can you protect it? Well, good question. So let's just take Utah, for example. Again, the homestead protects $42,000 of equity per person. So it's 42 for one, or 84 for 2. Here's the example. You're married and you live in Utah. Your home is worth $500. Your mortgage is $200. So do the math, $300 of equity. Okay, you get sued. The bad guys win, you lose. Not a good thing. Can your judgment creditor lien your home? And the answer is yes, they can. He can lien your home, and he can actually begin foreclosure 15 days after obtaining the judgment. Okay, so that's not a big, deterrent. Just another comment on the homestead is homestead laws are very user-friendly. You can be sued, have the event happen, get sued over the event, you're in the middle of trial. The day before judgment comes, you can go record a homestead on your property, and yes, it's effective immediately. So that's the good news. But Homestead doesn't help people that have significant equity in your homes. So they sue, they foreclose. What happens? Lender gets the first 200. They got a first lien on the property. You get the next 84 under Homestead. Homestead says this, how much goes to you? You're the next priority. Creditor gets the rest. Okay. So you take the 84, put it in your checking account. 2 weeks later, creditor comes and cleans out your account. Not good. All right. Is it over then? Not even then, because they can continue to go after any of the non-exempt assets, again, not IRA, 401k, those kind of things, until satisfied in full. So, question, well, why can't I just put my home in an LLC? And the answer is, in order for the LLC to work, it has to be treated as an independent third-party entity. Okay, so you have your house in there, you deed it in. If you don't treat it as an independent third-party entity, you open the door under the alter ego theory for somebody to get in. So how does this work? Will the creditor prevail? And you better count on it. Okay, so let's talk about this. Okay, so, well, it's easy. All I have to do is maintain my LLC as a separate entity distinct from me. Sure, you can do that. Unfortunately, you just created a lot of tax liability that didn't exist otherwise. Okay, why is that? If you were treating it as a separate entity, you would need to pay rent to live in the home. You live there tax-free, rent-free. That's, by definition, alter ego. You're treating it as your own entity. So let's say your neighbor owned the house and your neighbor's house were in there and you lived there. Would you have to pay the neighbor rent? Well, of course you would, unless your neighbor was very generous. Mine are, but not quite that generous. Okay, so in order to treat it as an independent entity, you would have to pay tax. Not pay tax, you'd have to pay rent. So you pay rent. Is the rent deductible by you? No. Is it taxable income to the LLC? Yes, do that in the reverse order. So rent is taxable income to the LLC. It's not deductible by you. And so what you did is you just went backwards. So people ask, well, how about if I just pay myself $10 rent? I go, that's not an independent, arm's length transaction. You're going to lose for sure. So it has to be bona fide, has to be real. So again, the bottom line here is if you are treating it, if you're doing it correctly for asset protection, you've created taxable income. If you don't treat it as an independent entity, you've opened the door for somebody to get it. So don't do it, bottom line. All right. So are there any other ways to protect your home? Good news is yes. In fact, this is what we're going to talk about in the next series, domestic asset protection trusts. Not tomorrow, but tune in for the next, click on the link and get the next seminar. The summary here with asset protection trust, just a little preview of coming attractions, is that you can set up a trust. You're the trustee, you're the beneficiary. In order for this to work, it's an irrevocable trust. People get freaked out over the word irrevocable, okay? Good news is it doesn't tie your hands in any way. So you're the trustee, you're the beneficiary, you put things in, you take it out, you do whatever you want to, okay? Sounds too good to be true? Well, it almost is, okay? The only catch is you have to have the assets in the trust held for 2 years before the liability arises. Under public policy considerations, it's bad for you to have something bad happen, hurry up and go do something so the claimant can't access anything in the trust. Not going to work. That's bad public policy. And so legitimate claimants, creditors can come in and get it. They define legitimate as anything happening within 2 years. So the consideration of the legislatures that do it is if something happens. So the principle is, are we going to let you take steps now to protect yourself against unknown, unforeseen things that may happen in the future? And the answer is yes, we're going to let you do that. Nothing immoral about that, against the unknown, unforeseen. And so they arbitrarily define unknown, unforeseen as occurring more than 2 years later. And so the bottom line is, yes, you can take steps now to protect yourself against things that happen in the future that you don't have to worry about it. Again, that is the topic of the next lecture. So this is a lot we went over. I hope this was helpful in some way. So again, the laws are out there. Use them to your advantage and don't get come up short because you didn't really take steps in advance. So wish you all well, and thanks for coming.